My name's Lisa McCurdy. I'm an attorney at Nixon Peabody in San Francisco. I've been involved in animal law issues for about 5 years now. We just had a panel discussion today with the San Francisco Bar Association discussing animal custody issues. The speakers were me, Bill Schoch, who is a pet guardian who was able to give us his personal account of a custody issue that arose in his life, and Joyce Tischler, who is the founder and general counsel of the Animal Legal Defense Fund. The issue of pet custody specifically, and really most issues that relate to animal law generally, are framed by the fact that under the law in all 50 states, animals are considered personal property. And for any of us who have pets, we know that they hold a much dearer place in our hearts than other types of property do: cars, tables, chairs, and those sorts of things. And so litigants and courts in particular are really faced with a difficult situation when custody disputes arise. On the one hand, courts as early as the 1940s, there was an appellate court in Indiana that referred to dogs as man's best friend, obviously recognizing that animals play a very significant role in our lives. At the same time, courts are really constricted by the fact that pets are classified as personal property, and so this comes up in custody disputes where they tend to be distributed like any other property that's part of the marital estate. It comes up in other issues where damages issues come up if an animal's been harmed or, heaven forbid, killed, and courts are trying to determine what amount of value to place on that animal. They're technically restricted to market value, but obviously there's a level of companionship that goes far beyond the market value of an animal in, I would say, all cases. So it's slowly evolving where courts are finding ways, and attorneys have to find creative ways to argue that animals should be classified as something beyond just personal property, or at least have courts consider the emotional value and the sympathetic value that they play in our lives. So that's really the challenge for both attorneys who work in this area of law and for courts as well. Given that animals are different than other types of property, ideally litigation can be avoided in these situations, and there's a couple of ways that people can try and go about that. One is a more proactive approach. A premarital agreement is an example of one of those things, or an agreement between roommates, or an agreement between a couple when they decide to live together and they're bringing animals into the home environment. Those are less common. People tend to not anticipate those problems at the outset, and so they're not commonly used, but they are contractual agreements that generally will be enforced. And so if that's something that people want to consider at the outset and provide for in the event that a relationship does go south, what will happen to the animals, that's one option to avoid litigation. Another is, once a dispute arises, hopefully the individuals involved can talk about what's in the best interest of the animal, and hopefully put their own personal emotional involvement aside and reach some sort of agreement, whether it's sole custody goes to one person or whether it's some sort of visitation agreement. Those tend to work out fairly well depending on the individuals involved. There are sometimes issues with if an agreement has been reached and at some point there's a dispute over that agreement. Sometimes courts don't want to get involved due to issues of supervision. They don't want to monitor, how many weeks an animal should be in one home versus the other. But some courts will get involved and consider the best interest of the animal, where the animal's going to be happiest, where it's going to live out its life in the best conditions. And so it's really just a matter of the particular judge, the particular court, and again, this is something that's hopefully headed in the right direction as animals become a more prominent part of society and courts start to recognize that. Given that animals are technically personal property still, whether we like that or not, An issue that comes up, whether you're dealing with negotiating an informal agreement between parties or whether you're in litigation, is establishing ownership at the outset, if that's possible. And there are several factors that can be considered in determining who is the quote-unquote owner of an animal. The first would be the purchase agreement or adoption contract, whose name is on that document. That's obviously indicative of who owns the animal. But beyond that, there are other items that courts will consider and that can be used in negotiating, hopefully, a informal settlement between the parties. One of those would be who has spent money on caring for this animal, be that receipts showing food purchases, whether that be who's spent money on vet bills, those types of things. Documents regarding who has registered the animal with the city, if that's required, where the individual lives. And another would be microchip registration. These days, more and more animals, thankfully, come from shelters or rescues, and most shelters these days require that animals be microchipped. And oftentimes, especially if they are taken straight out of a city shelter, those documents will be registered to the particular owner, and so those documents will be very important. A little bit of a twist is when you adopt an animal from a rescue group. Sometimes those documents will stay in the name of the rescue group, and they might not be as helpful in determining ownership between the two individuals in those circumstances. But those are 4 types of evidence that can be used either to negotiate between the parties who really is the quote-unquote owner of the animal, and also things that courts will likely look at in determining legal ownership.